welcome to the Law Lab. Here, we dissect and unpack everything legal. My name is Jacqueline Opoku, and today we'll be discussing contract law, mainly focusing on terms of a contract. In our previous video, we discussed what terms of a contract is and we looked at the definition, and also we looked at the classification of terms of a contract. So we'll be focusing basically on ascertainment of terms of a contract. When we say ascertainment, it simply means that we are looking to see what constitute terms of a contract, or the statements in the contract that are supposed to be bound by the parties, irrespective of whether or not they agreed or they did not agree. First, under the ascertainment of the terms of contract, we'll be considering written contract. When we say written contract, in simple terms, it means a contract which has been put into writing. When we look at Section 11 of the Contract Act 1960, Act 25, it simply states that even if a contract has been entered into before the coming into force of the Contract Act or after, and the contract was not put into writing, it does not mean the contract is going to be void. That means when parties enter into a contract, it necessarily doesn't mean that they have to put the contract into writing, but for evidential sake in the courtroom, it is important or it is advisable for parties to enter into a contract and then writing the contract down so that in any situation where they are asked to lead or produce evidence, they'll be able to show their agreement or their contract in writing. As I've already stated, written contract means you are putting your contract into writing. And the law simply states that when a contract has been put down into writing or has been reduced into writing, the parties are bound by the content in the written contract. Hence, they are supposed to perform their part of the contract based on the written contract which they produced or which they entered into. When negotiations are made, most times people make the negotiations in oral or they verbally make the negotiations. But in order for your contract to be binding or for evidential purpose in the courtroom, as I've already stated, it is advisable that parties must put their agreement into writing. Once an agreement is put into writing, the general rule or the law is that once a contract is reduced into writing, the court will not be ready to admit any extrinsic evidence in order to vary, add, or contradict the terms of the written contract. When we say extrinsic evidence, it simply means oral evidence. Most times when negotiations are made, parties may forget or they may sometimes remember to put everything into the written contract. But there are situations where the parties might even forget that they stated this in their oral negotiations. Hence, when they go to court, they try to convince the judge or the court that, oh, when we're trying to enter into the contract, these were our oral agreements, but then we forgot when we were writing them down or when we reduced the contract into writing. In this situation, the court will be very reluctant to admit the oral evidence in order to vary or contradict or add on to the written agreement. This is because they may not be in line with each other or they may contradict each other, the oral agreement and the written agreement. And in law, anything that is written has more probative value as evidence than the oral agreement. Hence, as I have already stated, the general rule is that once parties reduce their contract into writing, they are bound by it, and the court is reluctant to admit any extrinsic evidence to vary or add on to the terms of the contract. Let's look at cases in order to support our law. As we already know, in law, to everything you state, you must have an authority. When we look at the case of Motors Trading Limited versus Nuno, in this case, the parties entered into an oral agreement before putting it down into a written agreement. The agreement that was put into writing, they omitted part of the oral agreement, and hence they decided that they are going to be bound by the written contract. There was a breach of contract and the parties went to court. The court stated that all the evidence produced, the written agreement or the written contract, is the supporting evidence showing that they had a contract between them, and that once parties have entered into a contract and have reduced the terms of the contract into writing, the court will not be ready to admit any extrinsic evidence to vary, add, or contradict the terms of the written contract. Another case to consider is the case of Wilson versus Bobe. In this case, he entered into a contract with sellers, but then when he was entering into a contract, in his mind, he entered into the contract as a guarantor and not as a party to the contract, meaning he entered into the contract on behalf of another party. But then the contract was reduced into writing and he signed. Despite being illiterate, he refused or he forgot to read the contract to ensure that he was signing as a guarantor and not a party to the contract. There was a breach as to the payment of the goods that were delivered. When he went to court, or when he was sent to court by the plaintiffs, he stated that he entered into the contract not for himself, but rather for another party, which we will say party A, and hence is not bound by the contract. The court looked at the contract as a whole and stated that the contract was wholly reduced into writing. Hence, the defendant is bound by the contract, and since he being illiterate, he has no excuse to state that he did not read the contract to understand that he was entering into the contract on behalf of another party. This case, Wilson versus Bobe, reinforces the general rule that once a party enters into a contract, or once parties enter into a contract, and the contract is reduced wholly into writing, the court will not be ready to admit any extrinsic evidence to vary, add, or contradict the terms of the written contract. So far, we have looked at ascertainment of a contract by considering written contract. Our next outline for today will be the exceptions to the general rule. I have already stated in previous videos that in law, to every general rule, there is an exception, or there are exceptions. The exceptions to the written evidence or the written contract is known as the exceptions to the parole evidence. The meaning of parole evidence rule simply means that when parties enter into a contract and the contract is written down or has been reduced into writing, the court is reluctant to admit any extrinsic evidence to vary, add, or contradict the terms of the written contract. But there are certain situations where the court will bypass this general rule known as the parole evidence and accept oral agreement by the parties. This is because most times during negotiations, the parties may make a lot of representations, and the representations are not just going to be mere representations, but they agree that these representations are going to form part of the terms of the contract. But when they were reducing it into writing, they may have forgotten to add it to the terms of the written contract. Hence, there are 8 exceptions to the general rule or to the parole evidence rule, and these exceptions are: the first one is parole evidence may be established or may be admissible to prove that the contract or the written contract is incomplete without the oral agreement. This means that the contract that they have entered into, the written contract, does not capture everything that they intended for it to be captured. Hence, the court will ask them during your negotiations or during your oral agreement, what were the terms that you wanted to be bound by it? And once the court realizes that both parties are in par, they are going to accept this oral agreement and make it and allow it to vary or add on to the written agreement. The second exception is that parole evidence rule will be admitted to prove the existence of a collateral agreement. What is a collateral agreement? A collateral agreement simply means that a contract or an agreement that exists side by side. Side by side simply means that they go hand in hand. Hence, the court, when admitting an oral evidence to support the written contract, they would admit it only if the oral agreement exists side by side with the written contract. For example, in the case of Shanklin Piers Limited versus Detail Product, in that case, the plaintiff owned a company and they wanted to paint their company, but they wanted a particular paint for the painting of their company. They went to the defendant's company, told them about their company and the colors they wanted to use, and the defendant agreed to supply the paint to them. Moreover, the plaintiff once again entered into a contract with painters to come and paint their office and told the painters that this is the paint I want you to use. Hence, go to Detail Products for the specific paint. Mind you, they have already entered into a contract or a written agreement with the defendant part, which is the detail product, and also another agreement with the painters, meaning the agreement between the plaintiff and the defendant exists side by side with the agreement between the plaintiff and the painters. The painting company, that's detail company, breached the contract by producing paint that was not of good quality. Hence, the plaintiff sued to enforce the contract or sued for a breach of contract. The court stated that although there was an oral agreement and that the court usually is not ready to accept oral agreement, the fact that the contract that the plaintiff had entered into with the defendant existed side by side with the contract, the oral contract that he has entered into with the painters. Hence, the defendant is bound to have produced quality paints for the painters to use to paint the plaintiff's office. The third exception is that parole evidence would be admitted to establish the existence of vitiating factors. When we say vitiating factors, they are factors that make a binding contract non-binding anymore, or rather, a contract that is legal or enforceable no longer enforceable. As I've already stated, examples of vitiating factors include fraud, misrepresentation, mistake, and many more. We would focus on vitiating factors in our episodes to come, but these are the examples I can give you. Another exception, or the fourth exception to the parole evidence or to written contracts, is that parole evidence may be admitted where a phrase in a written contract is ambiguous. Ambiguity means that they are contradicting each other, or the words used in the contract is absurd. Hence, the court will be ready to accept an oral agreement to contradict, to add, or to vary the written contract to make this absurdity come into fruition, or to make the parties understand the contract they have entered into. Another exception to the parole evidence or to the written contract is that parole evidence or oral contracts will be admitted to show or to prove the existence of the plea of non ex factum. The meaning of non ex factum is that this is not my agreement, or this is not my deed. Although you have seen my signature on this agreement, it does not belong to me, because I was either deceived, or the contract was misrepresented to me, or I did not understand the terms of the contract, but rather I signed because I wanted us to go on with the contract. Hence, parole evidence or oral evidence would be admitted to show the existence of a plea of non ex factum. The sixth exception is that parole evidence will be accepted or will be admitted to the court where the written contract do not reflect the true intentions of the parties. Meaning, the parties may have entered into a contract, but there had been a mistake as to the fact that they both had different understanding to the contract that they had entered into, or the written contract. Hence, the court will admit oral agreement that existed when they were negotiating the contract, and the court would admit this oral evidence in order for the parties to know that there was a mistake to the understanding of the agreements they had entered into. The seventh exception is parole evidence will be admitted to show that the operation of an entire contract had been suspended until the occurrence of some event. That means that the contract they had entered into, the written contract they had agreed and signed, they suspended the contract until an oral agreement was accepted by the parties to continue with the contract. For example, A and B have entered into a written contract and they decided that, oh, let's suspend this contract for some time being. And within few months, A told B that I am ready to enter into this contract, or I am ready to perform my part of the contract. Mind you, the time she agreed to perform that part of the contract, there was no written contract to back her up in court. The court would admit oral evidence to show that they suspended the contract but then they orally agreed to continue with the contract. The last exception to this general rule is parole evidence or oral evidence would be admitted by the court to show the existence of custom or trade usage. Once again, the last exception is that parole evidence rule would be admitted to show the existence of a custom or trade usage. This means that there are situations where between a certain particular group of people, or there are situations in which certain parties to a contract are within a certain trade, and in that trade they have a usual way of entering into a contract, and then when entering into a written contract they may not have added this trade usage to the contract, but it is a right or a common knowledge to these parties because they are in a common trade, and hence the court will be ready to admit an oral evidence to support their claim that the contract or the term which was omitted from the contract is a custom. For example, market traders, maybe between two tomato sellers, they've agreed or they always sell to each other when each other do need tomatoes. Or for example, a mango juice seller and a mango seller, there is an agreement between them that every time or on the 26th of every month, the mango seller is supposed to sell mangoes or deliver mangoes to the mango juice seller. This may not have been added to the contract, but because it has become something that it has developed into a custom or a continued practice between them, the court will state that although 26th of every month was not included in the contract that the mango seller is supposed to deliver mangoes to the mango juice seller, although it was not added to the written contract, since it's a continued practice between the parties, they are bound by that contract. So far, we have looked at terms of a contract in our previous video. We looked at the definition of terms of a contract. We looked at the classification of terms of a contract. And in today's video, we have looked at the ascertainment of contract, terms of a contract. And there are different ways the court will ascertain whether a statement was supposed to form part of a contract. The main topic we looked at today was written contract. We looked at the fact that once parties enter into a contract and they reduce the contract into writing, the court would be ready to admit extrinsic evidence to vary, add, or contradict the terms of a written contract. We have looked at the exceptions. Thank you for joining me on the discussion on terms of a contract, specifically ascertainment of a contract, and detailing into it is a written contract. Thank you once again. Continue to like, subscribe, and share to your friends that the Law Lab has introduced a topic called Terms of a Contract. Thank you and have a nice day.